Aron, would you mind telling us about employees and contractors? What types of contracts should we have in place?
Yeah, sure. So internally, the employment agreements or independent contractor agreements are two different kinds of agreements, and that's really for two different kinds of relationships that you're going to want to have in place with certain people. You don't need them in place. So let's talk about first, when does the need, when do you hit that threshold? If you just have, for example, a receptionist or an assistant, and the only real thing you have with them is an hourly wage, maybe some fringe benefits, then you probably don't need some sort of agreement in place. But if they're the kind of person who's going to be intimately connected with your business or learn all kinds of details that you don't want getting out to the public, you may want with them, instead of an employment or independent contractor agreement, you may want some confidentiality agreement in place just so they understand they shouldn't be sharing this information with the public. So for example, my assistant, even though I don't have an employment agreement with them, I have them sign an NDA, a non-disclosure agreement, so that they understand all the information that they're getting exposed to, client information, details about the firm. They can't share that with the wide world. So that's kind of a base level agreement, maybe even pre getting an employment or independent contractor agreement for some of those first few employees. Once you grow to a certain size, maybe 5, 10 employees, it depends from business to business, you're eventually going to get people who you may want to make sure are locked down in various ways post-employment or post-relationship. So what I mean by that is somebody that you don't want to be contacting your customers, somebody that you don't want to be stealing your other employees and setting up shop across the street. So having non-competition and non-solicitation provisions are the kinds of things that you want to put into those agreements. And it's important to know what kind of person you're dealing with, whether they're independent contractor or employee, at least in Texas, because independent contractors can't be subject to a non-competition agreement. Employees can. However, you can still, for independent contractors, have non-circumvention agreements, non-solicitation provisions, and things like that can still protect your business, but it's not quite as broad of protection as a non-competition agreement.
Okay, so for everyone joining us today, we're talking about contract essentials for small business. And right now, what Aron is sharing with us are contracts that you should put in place that protect you in one of 3 categories of relationships that you will have, and that's with your contractors and your employees. And so as for Aron, thank you for explaining to us that we would want to consider having that there's different types of categories. So the more intimate the relationship is with the employee, the more you might want to have a more strict contract. And so can you explain to us, what is the risk? So you talked about if it's a receptionist, perhaps she doesn't have access to really intense information, but there's a different type of employee, one that maybe is a sales rep, a CEO, a vice president.
Yeah.
What are the risks that you're facing? What are we protecting ourselves from when we put in place a non-circumvent and a non-compete, these contracts that you're recommending?
Yeah, so the risk you run if you don't do that is that after they leave your employ, they can end up setting up shop across the street. So, you can't tell people not to have relationships with the people that they have relationships with, but if they were introduced to those people through you, so if you built out this great prospect funnel, this great sales funnel, and built this great network, and then introduced them to that network, and so the only reason that this person that became your top salesperson became that and did that within your industry or within your area was because of you, you'd want to protect that. So that way they don't just go either to a competitor across the street or across town or set up their own shop. And so that's the purpose of the non-compete, because once they leave, if they are the main person, they're the face of the company for some of those for some of those customers, then those customers may leave to go with them. And so you want to make sure that there's some protections in place. And we'll talk about this a little bit later, but then you would also tie that in with any agreements that you have with those customers, perhaps to say they can't leave with one of your employees if your employee leaves.
Right. So that's helpful. So anyone who's watching, what we're talking about then is protecting ourselves from risk. So it might feel frustrating or annoying to put in place a contract and to have to think through creating templates like this. I know for myself, I'm a busy entrepreneur. I don't really have time, and I try to focus on the most important thing because there's a million things I could be doing. But What Aron is explaining is that there's risk in the future. for when a contract goes sideways. And if I do consulting for small businesses to help them grow, and I can't tell you the number of successful companies. It's when they're unsuccessful or when they're like brand new, they don't put in place these contracts because they don't think they need it. They can't imagine a world where they'd be so successful that anyone else could hurt or care about their company and their revenue or their processes. But it's once they become successful that it's hard to, you can't go back retroactively and put those contracts in place. And so your number one sales, he can leave and go work for your competitor. And suddenly he has all of your pricing, all of your contact information. And that did happen to a client of mine. And daily they are having to deal with that person try to outbid them and compete with them in the same exact identical space. And so we're talking about avoiding risk. That's the point of a contract. And so we're talking about, again, employees and contractors. So Aron, can you explain to me based on that, what is the action item? Like when should we go to like LegalZoom and it's okay to use more generic templates and NDA? And when is it important to actually hire an attorney? And what would that kind of look like in terms of time, cost? Can we use that template again as an investment?
So I'd say once it rises to the level of needing some sort of non-competition or non-solicitation provisions, once it rises to the level of needing those, at that point, I'd say don't go to LegalZoom. Don't try to bootstrap it, because different states have different requirements, and different states have different laws, and also different industries might look different. And it's important to understand what are the courts actually enforcing. Because to give an example, in Texas, if you write something that's overbroad, then during the period of time that they're violating it, they're not going to be punished for it because you had an overly broad restriction on them. And so making sure you get legal counsel if it rises to the point where you feel like you have something worth protecting and want to put those provisions into a contract is important. I think, perhaps for basic confidentiality agreements, if that's all you're doing is just a basic confidentiality agreement, that could be something you get on LegalZoom. But if we're talking about employment agreements and independent contractor agreements and putting additional restrictions in there, then you should get an attorney. In terms of cost and outlay, that's going to look very different based from state to state, and even from region to region within states. If you're in a more rural area, it may be cheaper. If you're in a more metropolitan area, it's going to be more expensive. But I'd say you're looking at probably on average a couple $1,000s, minimum $1,000 up to several thousand to get some good independent contractor agreements and employment agreements in place. And then you can reuse them. Most firms will say, look, we'll put these templates together for you, and then you can use them with all your employees going forward or all your independent contractor relationships going forward. So it's a long-term investment. And so I would say action item is basically once you start having somebody else that's client-facing or customer-facing or vendor-facing, then that person is probably getting exposed to relationships that you want to protect. And you want to protect those from the inception of that employment or independent contractor relationship. So that's the point at which you should probably go get an attorney and try to get some contracts in place.
Man, Aron, I love what you're saying. And had I not, again, for anyone watching, I'm a business growth consultant. And if any of you guys want advice about hiring and creating standard operating procedures, job descriptions, hiring processes, you guys can reach out to me on my website, emilyannpage.com, and schedule a free consult. And if you are in the state of Texas and you want to get a quote from Aron to be able to create those types of contracts, you can go to his website, which we have posted in the comments and chat. It's very simple. You can also connect to him on LinkedIn and send him a quick message, but he can help you with any of that. We just had a comment and a question from Nokomis Home Fragrance. And the question is, so you suggest having new employees sign non-disclosure agreements. So you answered that a little bit before. Can you just repeat it so it's super clear to them that
if
your opinion is?
If they're going to be dealing with sensitive information from the company, then yes, because that way, I think just as a matter of course, it helps to impress upon them the importance of keeping information that is private to the company private and not telling the whole wide world about it. And so, if it's somebody that is not going to be dealing with any sensitive information, and for example, if you've got a large company, like I worked for Target or McDonald's when I was growing up, I don't need to sign an NDA because they're teaching me how to fry fries and deal with the cash register. But for most small businesses, your first few employees are going to deal with sensitive information because they're going to be dealing with your customers, they're going to be dealing with your vendors. They may see the books of the business if they're helping you with some bookkeeping. And so any of those would definitely warrant getting an NDA.
Yes, I agree. And I love hearing what you have to say, Aron, because it's just really strong advice. And this is something else, and I'd love to hear what you think about it. But even, in some cases, it may never be in your best interest to litigate against a entry-level employee who maybe, let's say, took a picture of, maybe said something. You may not ever be in a situation where you want to litigate someone who's not a high-level employee. But it is just by having that contract in place allows you to have a conversation with them to be sure that they are clear what your expectations are. If you, for example, own a gym, you don't want the receptionist taking pictures of people and sharing it on her personal TikTok. These things, you may never litigate them if they did it because it may not be worth your time. But these contracts are supposed to be encouraging healthy relationships. So that it's a great opportunity just to have that conversation with them and clarify what the rules of employment would be working with you.
Yeah, it's like the phrase, as the saying goes, an ounce of prevention is worth a pound of cure. I mean, that's the way I look at contracts. You're being proactive, and that ounce of prevention really does pay for itself in the long run, I think. And as you mentioned, large successful companies, they try to get those things in place early and then make sure they're part of the ways that they work internally, standard operating procedure.